All right, item 4.3 is new legislation for community colleges. I've asked our legal counsel, Mr. Riley, to provide a brief overview of the 4 pieces of legislation that will be affecting community colleges. I believe the legislation involves interpretation of that legislation was sent to you last week. And so I've asked Bob to give a brief report on those pieces of legislation that have a direct effect on us.
Thanks. Very briefly, I want to talk about the 4 pieces of legislation. The first piece of legislation that I would like to discuss is the Local Government Travel Expense Control Act, which technically comes into effect January 1st, 2017. However, we have to have we cannot pass or approve expenses after March 1st, 2017 unless we follow the provisions of the Act. So our basically effective dates, we've got to have the policies in place and start following the Act on March 1st, 2017. Specifically, the Act provides that the local public government has to pass a resolution or ordinance that at a minimum, 1, defines the type of official business for which travel, meal, and lodging expenses are allowed. 2, sets the maximum allowable reimbursement for travel, meal, and lodging expenses. And 3, creates a standardized form for the submission of travel, meal, and lodging expenses. Section 10 of the Act requires the development and use of the standardized form, and the request for the reimbursement must be supported by minimum documentation required under Section 20 of the Act. The form has got to provide for either an estimate of the amount of the costs of the travel or actual receipts that's being provided after the event, the name of the individual requesting reimbursement, 3, the job title or the title of the individual who's asking for the reimbursement, and 4, the dates and purpose of the travel. Importantly, an officer or employee who makes a request for reimbursement which exceeds the maximum allowed under the district's or college's policy, that request must be approved by a roll call vote by the college at a college meeting, at a board meeting. And any of these expenses for any member of the Board of Trustees must be approved by a roll call vote at a meeting of the Board of Trustees. The Act also has finally a provision that prohibits the use of public money for entertainment unless it is quote unquote ancillary to the purpose of the program or event, which would have to be related to the business of the college. The statute doesn't define what ancillary to the purpose or of the program or event is, and we obviously are urging caution to our clients with regards to how expansive that can conceivably be interpreted. Another statute that has been enacted is the Community College Trustees Leadership Training Program. Trustees for community colleges who are elected or appointed to fill a vacancy lasting at least 1 year's duration after January 1st, 2017. So you have to be elected or appointed to a vacancy after January 1st, 2017 for this to apply. Those individuals are required to complete a minimum of 4 hours of professional development and leadership training. The new law requires the appointed or elected members of the Community College Board to complete the 4 hours on various topics, including but not limited to open meetings laws, community college and labor law, freedom of information law, contract law, ethics, sexual violence on campus, financial oversight and accountability, and audits and trustee fiduciary duties. If the training requirement is not completed, the board secretary must send a notice to the elected or appointed members of the board that would be effective, stating that fact. And the college's website must also contain the name of all elected or appointed voting trustees and whether or not they have successfully completed the requirement of training. A third piece of legislation that was enacted is the, we refer to it as the Employment Contract Transparency Act. It applies to employment contracts of presidents and chancellors of community colleges entered into and amended, renewed, or extended after January 1st, 2017. It does not apply to collective bargaining agreements. Obviously, presidents of colleges don't have collective bargaining agreements, and that's subject to collective bargaining agreements. The contracts entered into with president or chancellors of community colleges must comply with the following requirements. Severance payments or contract buyouts can be placed in an escrow account if there are pending criminal charges against the president or chancellor. Final action on the formation, renewal, extension, and termination of the employment contract must be made during an open meeting of the board. That's currently the law anyway. Public notice in accordance with the Open Meetings Act must be given prior to final action on the formation, renewal, extension, or termination of the employment contract. That is also the current law anyway. This, however, must include a copy of the board item or other documentation providing at a minimum a description of the proposed principal financial components of the president's or chancellor's appointment. And we're doing that anyway. So we're already in compliance with that. Any performance-based bonuses or incentive-based compensation must be approved by the board in an open meeting. Again, already required by statute, and the board's already, would be in compliance with that. And it must be made available to the public no less than 40 hours before the board approval of the bonus or incentive-based payment. Board minutes, board packets, and annual performance criteria goals must be made available to the public on the community college's website. There is also provision regarding executive accountability. Each board must complete an annual performance review of the president of the community college, and annual performance reviews must be considered when the board contemplates a bonus, raise, or severance agreement for the president or the chancellor. The final piece of legislation I just wanted to update the board on is what I will refer to as the lame duck board of trustees limitations. The lame duck legislation basically provides that a board of trustees cannot amend or enter into a new employment contract with a president or CEO before a new board is being sworn in. The limitation specifically kicks in 45 days prior to Tuesday following the first Monday in April, an odd number of years. For the election. 45 days.
Perfect legal language. I love it.
Otherwise known as 45 days prior to the election. The act does provide for an emergency exception, allowing an outgoing board to act during this 45-day blackout period. If there is a reasonable emergency arises that would require the approval or renewal or extension of the employment agreement. The approval or the extension, however, will terminate on the 60th day after the first organizational meeting of the new board. So if there is an emergency and the contract for some reason is amended or extended in that window period, it can only last for 60 days following the organizational meeting of the new board. And a reasonable emergency is defined as any imminent need to maintain the operations or facilities of the community college district, so long as the need is due to circumstances beyond their control. Hurricane, tornado, decimates of however something. There's other statutes that are out there, but I thought I would pick these four because they were the most dramatic.
Good. Thank you, Bob. Questions?
Bill?
For Bob? Yeah.
I was going to save these comments until I did my ICCTA report, but I think it's really a good thing. At our last ICCTA meeting, the training session that we had was actually put on by our very own firm, Robin Schwartz, on the very new laws that Bob's talking about, plus some additional ones as well. So it's nice to know that our own attorney is actually doing the training for the statewide organization of trustees on the new legislation. So thank you, Bob. We appreciate it, and I think this will also help with some consistency across the state as well. So thank you.
Thank you. I was going to mention that we actually are one of the training.
Okay. Any questions for Bob?